Let us hear from our esteemed keynote speaker, Professor Niloufer Selvadurai, Macquarie Law School, who will be joining us online as she shares her thoughts on her intriguing topic, the IP issue of our era, patent protection for AI-generated inventions.
Thank you so very much for your kind introduction. Can everyone hear me? Yeah, lovely. Yes, and a special thank you to your Dean, Professor Rizwanul Islam, who I have known for many years, over a decade. I knew Rizwanul as a PhD student, so I'm really proud to see him as Dean, and he is a brilliant intellect and a brilliant leader. So you are very fortunate to have him. And so thank you very much for having me here as well. I'm very honored to be with you. I'm sorry I can't be with you in person, but seems to be a good connection. Fingers crossed it'll be all right all through it. So let me share my screen if I can. I think it should work. Let's see. How's that? Can you see that? Can you see my screen? Great. Let me just move this across. So as was mentioned, I'll be talking about what I consider to be an IP issue of our era. Maybe I should have put A, not the patent protection for AI-generated inventions. Now, copyright protection for AI and all the training data issues, people, creative community complaining about copyright being breached by AI systems has got a lot of media, a lot of popular attention, but I would suggest that patents is actually a very important issue in terms of economics for everybody and the whole development of the AI technology is very much dependent on the protection that we get for patents, because patents drives R&D. So we're going to look at the issue of patent protection for AI-generated inventions. So the central issue is, and I know this is going to be a bit of a nuisance, should AI systems, so the AI algorithms and the systems, be considered inventors under patent law? So not just the people who made or developed the AI system, but also the AI system itself. Because if we only recognize patent protection for the developers of the AI system, it impedes the sale, the licensing, and the dealings with AI-generated inventions. It's a bit of a barrier for small fintechs and tech startups. But if we can consider that the AI system itself can be an inventor, it lets there be a lot more commercialization of AI systems. So that's the driving basis, and I'll come to that in a minute as well. So what I want to talk about is an article I've just had published in the Case Western Reserve Journal of Technology Laws, Inventions Without Inventors, the Need to Recognize AI Systems as Inventors. And I've also got a little bit of a discussion in a forthcoming paper in the Oxford University Press, International Journal of Law and Information Technology, on seeing the full picture, an integrated regulatory model for AI. That's a small part of that paper. Oh, it's a bit of a lag. Sorry. Okay, because my argument is a bit complicated, I thought I'll just give a little summary. So, the overarching objective of patent law through history, and it's been a long history, it started back in 1500s, has been the support of innovation. The clear focus of patent judgments has been whether an invention is inventive. So it's always been about how inventive is this invention? Vacuum cleaner, a bit of a car engine, a computer algorithm, how inventive is it? The characteristics of the inventor have not been the focus of analysis. So it's curious and a bit unfortunate that incidental references to individuals and persons, he, the pronoun he, variously scattered through patent statutes, have actually operated to deny recognition of AI inventors. And this is the clear result of a global test litigation called Taylor and Commissioner of Patents. It was initiated by a colleague of mine, Professor Ryan, in the University of Surrey. And he wanted to test this in the courts. And all of the courts, except for a few dissenting judgments here and there, have said an AI system cannot be an inventor. And Professor Ryan and I are people who think that is wrong. The majority of intellectual property lawyers probably disagree with us. So let me go through my argument for why I think AI-enabled inventors should be recognized by patents. So let's look at the historical and theoretical underpinnings of patent law. So historically, the law has been very reluctant to confer monopolies on private entities. But in the space of patents, they make an exception. And the reason is they want to support innovation, research and development, and progress. So as far back as 1474, in the context of the Italian glass industry, the law formally said that there would be monopolies for new arts and machines of, and I quote, utility and benefit. Then in England during the reign of Elizabeth I, the Crown granted monopolies for what's called new manners of manufacture. Again, the focus is on inventiveness. And in subsequent centuries, patent litigation has centered on whether the claimed invention is inventive and novel if it adds to the knowledge in the field. And echoing the judicial discourse, the theoretical scholarship on the rationale for patents law has also contained little analysis of the inventor. The only place where human attributes actually come in to question is on the motivations of inventors and the predicted behavior of inventors. So some economic models around patents make assumptions as to the motivations and behavior of the inventors. But interestingly, these assumptions assume a rational inventor who makes commercial decisions that are rational. Now, this can be attributed to an AI system, which is usually designed to be rational and based on sort of its data. If the economic modeling took into account spontaneous, irrational aspects of individual character, that might have been difficult, but it doesn't. It assumes a rational inventor. And on the basis of current sophistication of AI systems and their cognitive abilities, it seems that AI systems do have the capacity to weigh and calibrate likely profits from patents, likely risks of disclosure, even more accurately than a human inventor. And so this is just a very brief summary of my paper where I go through history and theory to say that there's nothing to stop an inventor, an AI inventor being recognized as an inventor under patents law. Now, I'll leave you to look at this. This is the actual Taylor litigation, the test litigation I talked about. So essentially the thing to take away from this was the central question was, does Davis, which was the name of the robot, the AI system that made the inventions, could it qualify as an inventor? So it wouldn't be expected that a patent application for a food container and a flashlight could shake the foundations of patent law. But that's what's happened. So this Davis AI robot, for want of another word, invented a flashlight and a food container, which, if you apply the test of inventiveness under the patent law, qualified. They were inventions. They were inventive. The problem was they were created by an AI system. And the courts around the world got quite angry and said, why didn't the developer of Davis, why didn't the developer, who is Taylor, why didn't you seek a patent? And Taylor said, I didn't make these inventions. I programmed the inventions, but I didn't actually invent them. It would be wrong for me to be claiming to be an inventor. He said, it's like a PhD student. I have trained this Davis. He's like a PhD student, but the output is not mine. And I know other people have said the same thing. I know this is not in this test litigation, but say in the area of neuroscience, there are all these huge number of brain images that we now have with sophisticated brain imaging. And someone has developed an AI system for analyzing these images. And the outputs that this system can come up with, and the connections and the interrelationships and the analysis, is more than that human inventor could ever do. So for the human inventor to say that that outputs of that AI system is their invention is actually wrong under patent law. They did not create that. They didn't actually come up with the outputs. They came up with the AI system. So they can have a patent over the AI system, but the outputs of the AI system should be able to be patented with the AI system being the inventor. So that's a two-step process. So, but all of UK, US, Australia, South Africa, and quite a few other jurisdictions have said no. And the reason is because of these words individual, the pronoun he in the statutes, and they can't get around it. And fair enough, I understand that. And so the question is, should we have statutory reform? Should government step in to change this legislation? Because I understand that the courts can't do it. When they see the word individual, they see the word he, the pronoun he. But so let me just present some arguments as to why I think the government should intervene and change the statutes. So personal pronouns, he, doesn't necessarily evince a parliamentary intention to limit inventions to humans. So just because they've used the word he and not it doesn't mean anything, because you could argue that Parliament didn't even envisage, they didn't foresee that there could be AI systems inventing. So the fact that they didn't use the word it doesn't mean that they didn't think it should be covered. So, and then there's an argument which was run in Taylor, but which didn't succeed, was that on the basis of this argument, any human inventor who didn't identify themselves as him or her would be denied patent protection. Now, a second reason for why I think governments should intervene is judicial pronouncements on the concept of inventiveness have dramatically evolved and changed with changing technologies. So let me illustrate. So originally, patents only applied to what was called tangible goods, goods that you can actually hold, vendable goods. Then it evolved to cover processes. Then it evolved to cover computer algorithms and computer software. So why can't the concept of inventor also evolve? And there's been a lot of discussion in the cases about how great patent law is because it's evolved with technology in terms of inventiveness. So in the High Court case of Darcy and Myriad Genetics, for example, in the context of DNA and gene technology, the High Court not only justified this, but celebrated this widening concept of inventiveness, saying it is a necessary feature of the development of patent law in the 20th and 21st centuries, as scientific discoveries inspire new technologies which may fall outside or inside the boundaries of patent law, that the law has evolved. So if the idea of what is inventive has evolved, why can't the concept of who is inventive also evolve? Now, so IP legislation has frequently been amended in response to technological evolution. Now, I just want to go into copyright for a moment. So this is like a little past incident which we can learn from. So in the 1980s, probably before many of you were active in thinking about IP, we had a problem with computer algorithms. So when computer software first tried to get copyright protection around the world, some courts, including Australia, said how can a computer software be a literary work and be protected by copyright? Copyright is for human creativity. But in the US, they actually said a computer algorithm, a computer software can be copyright protected. It can be a literary work. Now, in hindsight, the US court has been celebrated as having been future thinking and having foresight into protection and how important computer software would be. Can you imagine computer software progress and innovation without copyright protection? And yet for a time there, that was a big question. And in Australia, because the courts didn't do it, the Attorney General intervened and changed the Copyright Act to add computer software to the definition of literary works. So I think this is patent law's moment. It's the same problem we had in the 1980s for copyright and computer software we're having with patents and AI. And like then, there were only a few people, I was too young to be involved, but there were only a few people who said we should have protection, copyright protection for computer software. The vast majority of lawyers said no. And where I'm feeling like this is the same situation. The vast majority of IP lawyers say no, AI cannot be an inventor, but I think in 10 years' time, it will be very different. And another thing is it's easier to get patent protection for AI than it was to get copyright protection for computer software. And it's because copyright law has moral rights. It's got moral rights, and there's a whole lot of stuff on human creativity, which is actually more aligned to copyright. Patents is not about human soul and imagination. It's really practical. It's like bits of air, car engines and vacuum cleaners and toasters and aeroplane wheels. It's really functional. So I think it's easier to use patents to protect AI than it was copyright. So we'll see what happens, but I think that in the next few years, we'll see quite a lot of development. And there are these broader commercial and societal considerations for having protection for AI-generated inventions. So it's not just a matter of formal legal interpretation, it has substantial commercial ramifications. If an AI system can be recognized as an inventor, the intellectual property in such a system can be licensed and assigned like any other intellectual property asset. This can facilitate the commercialization of AI by supporting R&D in AI, and the resulting system itself can be easily marketed and traded. If it's not recognized, the entire corporate entity that owns that system would need to be transferred in order to transfer the underlying IP in the AI system that's inventing. So in order to support commercialization and economic progress, it's really important to protect AI-generated inventions by patents. And the computer scientists I work with are really in favor of it. But lawyers are a little bit more traditional, and also, we've got the word individual in the legislation, so I understand it has to be changed. Now, another little, before I conclude, an interesting observation. In some of the judgments, including in the UK, this AI system, Davis, is called the Thing. And I don't know if anyone's familiar with the novel Frankenstein by Mary Shelley. It's also been a movie. But in that novel, the monster, which is created, like the monster which is created by a human being, is called the Thing. And it struck me that it was a similar thing. I don't know if that judge was doing it on purpose, the court was doing it on purpose, but it's this fear of the machine creator, the fear of the machine creator who is sort of seen as a threat to humanity, a threat to human imagination, always the outsider. And the monster or the thing in Frankenstein is always in the forest, feared, considered incapable of civilized thought. And calling Davis, which is the AI system in this Taylor litigation, the thing, just reminded me of that. But there is a very interesting dissenting judgment by Justice Beach in the Federal Court of Australia. He was overturned. He was a single judge. But he says, why can't our creations also create? Yeah, so that's a really interesting thing. So why can't our creations also create? And I'll just read to you from his judgment because it's really interesting. It says, much of the Commissioner of Patents argument, and he was denying patent recognition, descended into dictionary definitions of inventor. But more is required of me than mere resort to old millennium uses of that word. If words are pictures upon paper, and if they're not crystals transparent and unchanged, but a skin of a living thought, they vary in color and content according to the circumstances and the times in which they're used. I need to grapple with the underlying idea, recognizing the evolving nature of patentable inventions and their creators. And he concludes with this phrase, which I like. There's no reasons why our creations cannot also create. And he suggests that if we don't get patent protection for AI-generated inventions, what we have is inventions without inventors, because these outputs are original and novel and inventive enough to be inventions under patents law, but we don't have an inventor because it's a machine and it's not an individual. So for all of those reasons, I suggest that we need to change patents law, and patent law is pretty similar all across the world. They have the word individual for the inventor. They use the word pronoun of he. They don't use the word it. So that just has to be changed. To me, that's a fairly small change. But so legally, it's a small word to change. But philosophically, I understand that recognizing AI systems as inventors is quite radical and people feel uncomfortable about it. And this is the one person I mentioned who was this dissenting judgment, Justice Beach in Taylor. And it's the view from the edge, or is it the future? So that's the full paper again. And if you want to see, and so that's a little short version. I think it's been 20 minutes, which leaves time for questions.